Quick disclaimer, this is an AI voice, which is not going to be perfect. There is a transcript in the description as well as subtitles for you to read along with. Mental capacity defenses are legal defenses where a defendant lacks the mental capacity to be held fully responsible for their actions, such as automatism, insanity, and intoxication. Non-insane automatism occurs when the defendant commits a crime while in an automatic state where the mind had no control over the muscles. The case of Bratty v. Attorney General for Northern Ireland set out the Bratty test, which has parts that must be met for the defence to be used. The first part of the Bratty test is that there was an involuntary action caused by an external source or reflex action, as shown in R.V. Kemp. Examples of external factors include a blow to the head of a swarm of bees, sneezing, hypnotism, and the effect of a drug. The second part of the Bratty test is that the act was completely involuntary, as shown in Broom v. Perkins. The defendant must have lost total voluntary control of their actions, and partial loss of control is not sufficient. The third part of the Bratty test is that the automatism was not self-induced, as shown in R.V. Bailey. Self-induced automatism occurs when the defendant knows that their conduct is likely to put them in an automatic state, such as with voluntary intoxication. Self-induced automatism affects specific and basic intent crimes differently. Specific intent crimes are any offence with a mens rea requiring intent, such as murder, whereas basic intent crimes are any offence with a mens rea requiring recklessness, such as common assault. Self-induced automatism can be a defense for specific intent crimes as the defendant lacks the mens rea for the offense, but it cannot be a defense for basic intent crimes as the defendant was reckless in putting themselves in an automatic state, as shown in R.V. Hardy. Insanity is a defense where the defendant can be found not guilty by reason of insanity. The case of R.V. Nathan sets out the three-step test to prove the defendant is insane. The first step is that there was a defect of reason, which means that the defendant's powers of reason must be impaired, as shown in R.V. Cluck. If the defendant is capable of reasoning but fails to use those powers, then this is not a defect of reason. Mere forgetfulness or absent-mindedness is also not sufficient. The second step is that the defect of reason was caused by a disease of the mind, which includes any physical disease that affects mental functioning, as shown in R.V. Kemp. The third step is that the defendant did not understand the nature and quality of the act and did not know it was wrong. Not understanding the nature of the act means that because of the defect of reasoning, the defendant did not understand the actual type of act they were doing, whether that be because they were in a state of unconsciousness or due to a mental condition, as shown in R.V. Antoine. Not understanding what they were doing was wrong meant that the defendant did not appreciate that what we're doing was wrong in the law, as shown in R.V. Windle. If the defendant successfully proves insanity, the jury must return with a verdict of not guilty by reason of insanity, and the judge can impose hospital order, supervision order, or give an absolute discharge. Intoxication is a full defense based on whether the defendant had the required mens rea for the offense. The lack of mens rea could be due to intoxication by drugs, alcohol, or any other substance. Intoxication can be voluntary or involuntary and affect specific and basic intent crimes. Specific intent crimes are offences that require intent for the mens rea, such as murder, whereas basic intent only requires recklessness for the mens rea, such as common assault. Voluntary intoxication can negate the mens rea for specific intent crimes and can lead to the defendant being acquitted for their charges if they lack intent, as shown in DPP v. Beard. However, if there is a fallback offence, such as manslaughter being the fallback offence for murder, then the defendant may be charged for the fallback offence instead. Voluntary intoxication has no effect on basic intent crimes as it is seen that becoming intoxicated is reckless, as shown in DPP v. Majewski. Involuntary intoxication can occur if the defendant does not realize the strength of the intoxicant they are taking, they are spiked, or their prescription drug has an unexpected effect, as shown in R.V. Allen. If the defendant is intoxicated through no fault of their own, they can argue that they did not form the mens rea for the offense for both specific or basic intent, and they will be acquitted. However, if the prosecution proves that the defendant did form the mens rea for the offence at some point before or after the intoxication, then they will be found guilty, as shown in R.V. Kingston. If the defendant is so intoxicated that they get a key fact of the situation wrong at the time, then they can rely on the defence if the offence is one of specific intent. If the offence is one of basic intent, and they do not have the mens rea for the offence, then there is not defence, as shown in R.V. Hatton. Thank you for watching this video on mental capacity defenses. I'll see you in the next lesson.